Yesterday, we talked about court cases dealing with national supremacy and civil rights. Today, we're going to talk about court cases dealing with the First Amendment and also rights of the accused. So, first of all, when we get started, we got to figure out what are your First Amendment rights. And if you can remember back to the way I taught it, it's religion, assembly, press, petition, speech, and specifically your freedom of those five things. Have your First Amendment rights ever been violated? What does separation of church and state mean? What is the Establishment Clause? Well, first question is kind of a personal question. Separation of church and state means that your religion and your lawmaking body are separate and they do not necessarily take the same ideals. The Establishment Clause just means that there is no official established religion in the United States. First case we're going to talk about today is Engel versus Vitale in 1962. The parents of a student sued a school over being forced to say a prayer every morning in a New York public school. The kid was Jewish, and he was being forced to say a Christian prayer, and so the parents sued, as they should have. And the decision is that students cannot be required to say a prayer in public school, as we do have the separation of church and state. That goes with the First Amendment, that goes with the Establishment Clause, and is an example of separation of church and state. Next is the New York Times versus the United States. This took place in 1963. The background is that the New York Times was trying to publish a set of papers called the Pentagon Papers, which would have revealed the U.S. war strategy for Vietnam. So that wasn't actually the problem. The problem was that the New York Times wanted to publish these papers, and it was going to make the U.S. military look bad, and the government didn't want to do that, so they told the New York Times that they couldn't publish these papers. So the New York Times sued the United States, and they went to the Supreme Court, and the decision is that the government does not have prior restraint in the United States, and the New York Times is allowed to publish those papers. Did not matter that it was government documents because they were not classified. All right, Wallace versus Jaffrey takes place in 1985. Background: school mandated that all students have a moment of silence for prayer. This kind of goes with Engel versus Vitale. And the decision is that the moment of silence for prayer is unconstitutional. Now, the moment of silence that we do at school every day is fine because it is not specifically for anything. It is, well, I guess it is for everything. You can do whatever you want in that moment of silence except talk. You can pray if you'd like. You can think about your day. You can do whatever you need to. You can be on your phone. You can listen to music for those 30 seconds or so, as long as it is silent. Texas versus Johnson in 1984. Joey Johnson burned a flag in protest of President Ronald Reagan's policies, but was arrested because Texas does not allow the burning of flags, or did not allow the burning of flags at the time. There is Joey Johnson right there. He was a member of the Revolutionary Communist Party Youth Brigade. And he went to the Supreme Court, and the Supreme Court decided that flag burning is a constitutional form of protest because the federal government cannot decide what people do with national emblems. And that goes with the First Amendment freedom of speech or expression. Next is Nazi versus Skokie in 1977. The background is the National Socialist Party wanted to run. They wanted to have a march and a rally in the town of Skokie, Illinois, which was a small Jewish community just outside of Chicago. And the town did not want them to, as many of the people in the town were Holocaust survivors. So they did not want the Nazi Party. However, the Nazis filed for a permit with the town of Skokie, Illinois, to have a peaceful demonstration, and was granted the permit. But the townspeople of Skokie did not want it they obviously did not want the rally because most of them did not want to see Nazis again. So the Nazi Party sued the town, and the decision is that hate speech is legal. You can tell anyone you hate them as long as you are not threatening in the manner of which you are telling them. And that's a kind of debatable form, but it is just one of the things that goes along with freedom of speech in this country. So, moving on to the rights of the accused. It says, which amendments deal with the people accused of crimes? Well, you got the Fourth Amendment that deals with search warrants. You have the Fifth Amendment that is your 5 different rights when in a trial. You have the Sixth Amendment, which grants you the right to an attorney. The Eighth Amendment, which is no cruel and unusual punishment. Mapp versus Ohio in 1961. Dalry Mapp's home was searched without a valid search warrant. What happened was Dalry Mapp was a part of a organization, like organized gambling ring, and there was another gambler that had moved into the town, or another gambling ring that had moved into town, and her boss wanted to put him out of business, so they got a bomber to go blow up the building that the other guy was in, not necessarily to kill him, just to stop his business. And it is thought that that man went to Dalry Mapp's house and hid, and the police knew that he was there, so they went to look for him. But they didn't have a search warrant, and so when they walked in, when they came up to her door, she did not let the police in. And so they came back later with a warrant, but it is thought that the warrant was false and it was never seen in court. So it kind of has the appearance that the police went back and just wrote up a fake warrant and came back and thought she wasn't going to check. So they came in, they did an illegal search, and they were looking for a person, but they found pornographic material. Well, the problem is, in a search warrant, you have to be very specific about what you are looking for, and you can only look in places that thing that you are looking for may be. So, like, if you're looking for a person, you can look in rooms, you could look in closets, you could look in an attic, you could look in a basement, but you can't look in drawers, or you can't look in, smaller areas where a person could obviously not fit. Well, the police found pornographic material in Dalry Mapp's home in a very small place, and so they had to throw that evidence out. There is Dalry Mapp right there. So this creates the exclusionary rule that says that evidence found in an illegal search cannot be used in court against a suspect. And if you hear that jingling, that's because I have my teacher assistants with me today, AJ and Piper, sitting here while I'm making this video. Anyway, so you cannot use evidence found against a person in an illegal search. And that goes along with your Fourth Amendment rights. All right, Gideon versus Wainwright in 1963. Earl Gideon was found outside a pool hall. He was accused of robbing it. He could not afford a lawyer and was sentenced to 5 years in prison. This happened in Florida, and the judge said that he thought that the case was so minor that Mr. Gideon did not need a lawyer. And so he was sentenced to 5 years in prison. Well, he appealed from prison, and it was granted that everyone must have the right to a lawyer, okay, no matter what. And if you can't afford one will be appointed to you. So apparently this judge or the Florida court system had been doing this for a while, where they were not giving people lawyers in minor crimes. And I want to say over 2,000 people were let out of prison after this. But Gideon's case was remanded back down to a lower court, where he was given a lawyer and he was found not guilty in his second trial. All right, Miranda versus Arizona in 1966. So Miranda was an immigrant who was arrested, convicted of rape and murder without knowing the legal protection granted to him. Basically, he did not know he had the right to a lawyer. He did not know he had the right to remain silent. He didn't know about his Fifth and Sixth Amendment rights. He barely spoke English, so he sat and was interrogated, and eventually just he confessed to the crime. Well, he goes to court, and he didn't know that he had those rights, and that is why when you have the right to remain silent is read to you while an arrest is going on. It is known as your Miranda rights, and it is because of Ernesto Miranda. Well, so Ernesto Miranda did kidnap, rape, and murder the person he was accused of kidnap, raping, and murder, and the confession could not be forgot. So this case was also remanded. He was given another trial, but it didn't really matter because he had already confessed to it. All right, In re Gall, 1967. All right, so the background is that a lady reports a 15-year-old neighbor prank calling her and saying sexually lewd things to her. And so the 15-year-old is arrested. He's taken to the police station, but his parents were not notified, which is a problem because when you are a minor, you have to be notified of your rights, but your parents also have to be notified that you are being arrested or that you are in police custody. The decision is that parents must be present, notified of juvenile arrest as part of due process, which is the Fifth Amendment. Then you got Furman versus Georgia, 1972. Furman broke into someone's home and accidentally killed the homeowner. He was given the death penalty. It was his word against the other guy's word. He said that he was trying to run away. He fell down. The gun went off and it hit the man, the homeowner, and killed him. He was not disputing that he killed the person or not. He was disputing whether or not he should get the death penalty. It goes to the Supreme Court. The decision is that the death penalty is for accidental murder is cruel and unusual in the Eighth Amendment. So you cannot be given the death penalty in a accidental murder. You can still be given life in prison and the typical murder sentence, but not the death penalty. Moving on to Gregg versus Georgia. This is probably one of the most interesting crimes or cases. 1976, Troy Leon Gregg violently murdered two men after they picked him up hitchhiking, and he was given the death penalty. Basically, he was hitchhiking, him and a friend. They decided that they were going to rob the people that picked them up. He had a gun with him. They stopped at a rest stop, and he shot the two men in their head, and hid their bodies and stole their car. He was arrested and convicted of murder and given the death penalty for a violent crime. And he sued and went to the Supreme Court under the precedent of Furman versus Georgia, but the Supreme Court said the death penalty is not cruel and unusual punishment because he intended to kill them and it was a violent crime. So fun fact about Gregg versus Georgia, Troy Leon Gregg actually escaped prison the night before he was supposed to be executed and made it all the way to Asheville, North Carolina. And in his jubilance, he went to a bar to celebrate him, quote unquote, getting out of prison. And while he was in the bar, he got into a bar fight. And at about 2 o'clock in the morning, on the day he was supposed to be executed, he died in a bar fight. So while he did escape from prison, he still died on the same day that he was supposed to die on, which I always think is very ironic. All right, guys, that is all the cases I have for you today. And as always, I hope that you have a great day, and I hope to see you soon.